point where you are going to be negotiating contracts, and by the end of this, you're going to know that it's not such a far-off thing we're talking about getting involved in negotiating these types of contracts. You will be able to have a good primer to give you the parameters of the rules you need to look at. Okay. History of sports law. Sports law is, in fact, part of the entertainment world. Chariot races, sword fights, naval battles, they were termed games of sport. And eventually, the people who put those events on would go and negotiate with people who would bring them athletes. We also saw probably the movie Gladiator. The lords of circus would be the ones who provided the talent for, these guys were mostly slaves that were going to get killed by the end of the show, and it was a valiant thing to do, get killed, but it was mostly talent, and this is where contracts came about. Now, times have changed. I'm happy to say that the best thing that an athlete has to look forward to is no longer dying in the name of the emperor. We have contracts that will protect us. Our jobs as attorneys is to see that all the athlete wants, because of their egos, what they want, and because of what we know, what we think they should have, we have to make sure that we get that for them. The agent and the attorney, agents are non-licensed attorneys, is pretty much what it comes down to in the theater of sports, and Frank's going to talk more about that. But they do a lot of the things that we do. If not for everybody wants to accept the Jerry Maguire type thing, it would be the unlicensed practice of law in many areas. That's why we'll get to a section where there is a teaming of lawyers and agents when they do the work they do, because otherwise lawyers would stand up eventually through the American bar and say this is pretty much the unlicensed practice of law, because they're doing a lot of negotiations and sometimes even drafting that we do. Modern day sports law. Sports law encompasses a multitude of areas. Each of the issues in these areas are complex. The areas, the basic legal concepts we deal with is contract, torts, and antitrust. Any of these sections of the law involve contracts. In fact, the basic fabric for everything we do is going to be based on contract law. But just like with entertainment law, the thing that we have to be concerned with are the industry standards. Although we're faced with a myriad of contracts, we must know, as entertainment lawyers, what is right to negotiate in a matter of contract. For example, say an agent, say a team comes to you and says, we would like to offer your, an agent comes to you and says, we'd like to sign your athlete to our agency, and we're asking for 10%. Now you might think, okay, 10%, finder's fee, the guy's going to go out and find work. 10% is not a bad deal, it's not that high, it's pretty good. So, all right, I'll negotiate with my client, I'll talk to him about it, and I'll negotiate with the agent, maybe get it down to 9%. Well, you'd be doing your client a huge disservice, because the standard is 4%, 3 to 4%. So it's important that you know what the standards are in the industry. How do you know these things? Publications, being involved anywhere searching on the internet. There's always things you can find on the internet to know what somebody's making, what the agencies are charging. In fact, just call the agencies. In this sports agency world, there are very aggressive people. It behooves us to be as aggressive when finding out the information we want to find out, because it's not going to be looked at negatively by anyone. It's just something that it's a standard to be done, especially on the coasts, where LA and New York, where it is the most aggressive for these companies like Octagon and things like that. So you would negotiate wrongly if you didn't know the industry standards. Same thing in the music industry. In the music industry, you want to know what the industry standards are. You go to Billboard or similar type magazines. They will talk about deals that are being made all the time. You can always find out deals if you go on online. And there's a bunch of different sources out there to find out industry standards for what you should be negotiating into contracts. Okay. You could also look at just sample form contracts. We've got some in here, and they'll give you an idea of what you should be discussing. The second thing is a tort area of sports law. In sports law, you have mostly assumption of the risk. You have your boxers getting in the ring on assumption of risk. These are legal principles that we are confined to. A boxer gets into the ring knowing he might get his block knocked off, as they say. But they do not expect, and nor do they have to remain not able to sue for, getting one's ear bit off. In the Mike Tyson situation where he bit Evander Holyfield's ear off, this is not something, an assumption of risk that he contracted for. This creates tort liability. So you have contracts and you have tort liability. In a football game, if a flag is thrown and then somebody all of a sudden attacks you, tackles you, it has its ramifications within the game, penalties and so on, but it does open up an area of both tort liability and possibly criminal liability. So there's tort, and what Frank and I do as well, the criminal stuff does come out. You have to defend your client against criminal things that take place there. But be aware, because in the sports game, nobody likes to talk about these extra things, like the tort and the criminal liability. Protect your client, even if it's not the popular thing to do. Prosecute against somebody who's hurt your client, even if it's not the proper thing to do. Because in the end, it's the right thing to do, not only for your client, but for the sports industry. Mike Tyson should have been prosecuted much more for that. Because what it tells the world is that someone can go do something like that in this game, and it really hurt boxing. Besides the tort of a physical tort, you have other torts, such as economic relations torts, including defamation and emotional distress. These things come up with actions that a player will do, sometimes actions that agents will do. Misrepresentation of contracts sometimes can lead to tort as well. There's criminal actions we talked about. You have the Kobe Bryant situation. While being an agent for a basketball player, being an attorney for a basketball player, sometimes you all of a sudden face some criminal charges being thrown at you. How to deal with them? I have a way to deal with these things when they come up. Minimize. A lot of attorneys, especially agents, they like to publicize. They like to make it the biggest thing in the world. Anybody know who Earl Simmons is? There you go. Earl Simmons is DMX. If you guys know DMX, he's a rapper. DMX lives right here in Teaneck, was having a dispute with his wife. It became a domestic dispute. He was represented by Brian Neary in town in Hackensack. And the police were called. When the police come, they do what they normally do, is decide to look around the whole house, and they found an arsenal of weapons, and they found a whole arena in the back for dog fighting and so on and so forth. What he had set up, although there was no dog fight actually happening at the time, what he had set up was every bit as bad as DMX's stuff. But, as Michael Vick's stuff. But what Brian Neary was able to do is simply get before a judge, Judge Venezia, who happens to be a former entertainer himself, so he was not distant from the situation entertainers go through. And on the same charge, of course, you have to give up all the guns. The government likes to take all your guns. But on the same situation as the Michael Vick story, DMX was able to do, Brian Neary was able to negotiate for his client a couple of spots for the ASPCA and $40,000 in some reparations. Now, the spots have run on MTV and all these other things, and he's done. His career has been injured by other things, DMX, but not by this type of thing. As attorneys for criminal clients, we might think at first it's good to make a big hullabaloo about stuff, and maybe in the rape cases it is to draw out who might also say that, hey, this girl said I did this to her. But in most of the cases, like the O.J. Simpson's thing with dogs, most of the things, it's better to keep quiet and not want to publicize everything. In fact, keep your guy away from doing interviews and just get to the heart of the legal matter. Let's not ever, ever lose focus that we're best as lawyers. We're not best as publicists and going over everything we want to do in the media, although it is tempting sometimes when the cameras come to your face. But back away from it and just be the guy in the background. Nobody better than that with a huge superstar athlete is Anthony Fusco. Anthony represents Mike Tyson, although nobody really knows that because unless he has to be in an appearance, he's very quiet about it. He won't do interviews about it, he won't do anything. Whereas everybody else who has anything to do with Mike Tyson's on TV 24 hours a day want to talk about him, including his entourage, people that drain his money until he has none left. Stay in the back, be the king maker as opposed to the king when you're dealing, and it is very tempting to not do that. Okay. Divisions of sports law. You have amateur, this is on page 3, amateur, professional, and international. Amateur sports, anything from casual weekend athlete, high school athletics, to intercollegiate sports, which are considerably organized. The rules for amateur athletes are usually divided into somewhat of the rules that they have in the professional field, age and weight categories. The NCAA, which Frank is going to talk about considerably, has about 1,000 member colleges and universities. NCAA pretty much runs the show for the collegiate athletics. Everything that you want, you can find for NCAA rules. Now, a lot of the universities, State College of this, State University of that, are run by states. So one would say that, okay, since they're run by states, there might be some state control. Supreme Court of the United States has suggested, although not found, that eligibility rules are not state sanctioned for constitutional law purposes. And that's important to know when you want to stand up and fight for a client when they're, you believe they're not getting their rights. That's why we have a lot of collegiate athletic teams that are, in some states, all white, in some states, all black. It doesn't reflect the proper ethnicity that one would think, the diversity that one would think might exist within the school campus. So somebody white wanting to get on a black basketball team might think they can come up with rules, a lawsuit. It doesn't work that way. The NCAA regulates, and as long as they're found to be fair and not violative with regard to their rules, those rules are allowed to be applied. One of the rules is talent. It's your talent that gets you on these teams.